The Data Protection Act of 1998 covers any personal data gathered and processed by you and your company. Personal data is defined as any information about living identifiable individuals, such as a name or address. The Act aims to promote high standards in the handling of personal information and so protect the individual's right to privacy. The effect is to amend the balance of rights back away from companies and towards individuals. Those businesses that wish to record, use, and/or sell a person's personal data will have to do so transparently. They will also have to tell the individual what information they are holding, and the person is entitled in law to change any of it that is incorrect. The Act basically requires that any company in the UK has to hand over on request whatever personal data they possess on that individual, whether electronically or on paper, for a fee of no more than £10 and within 40 days. All companies, no matter what their size, are equally affected. Any that refuse to comply can be fined £5,000 plus costs at a magistrate's court, or an unlimited fine in the courts above that. However, the 40-day period only starts when you have sufficient information to find the data, when you have enough proof that the person is who they say they are, and you have received the maximum £10 fee. The company has to disclose, upon request, all information they hold on an individual, both in electronic and paper format. It also has to be able to explain why that information is being processed, who may be given that information and where it came from. All this can be supplied as a computer printout, a letter or a form. To obtain this information, an individual need only send a letter to the relevant company. Companies need to follow 5 basic principles of good information handling. These are that the data must be obtained fairly and lawfully, held only for specific and lawful purposes, and not processed in any matter incompatible with these purposes, relevant, adequate, and not excessive for these purposes, accurate and where necessary kept up to date, not kept for longer than necessary. As a company managing large amounts of personal data, you will almost certainly need to register with the Information Commissioner's Office. There is a 2-tier charging mechanism depending on an applicant's size and turnover, but for the vast majority of agents the annual charge is £35 per year, which can be completed online. You will also need to ensure that you comply fully with the Act. In particular, if anyone asks for the information, you have to give it. If they ask for it not to be used for direct marketing, you have to make sure it isn't. And if they ask for wrong or inaccurate data to be changed, you have to do it. You also have to make sure that adequate security measures are in place to prevent the unauthorized disclosure of the information, and that the data is not sent outside the EU unless you are satisfied of that country's security arrangements. This is a complicated area, and you need to ensure that you fully understand your responsibilities. More comprehensive information can be found on the ICO's extensive website, www.ico.gov.uk.